What are you on? Okay, so this is the March meeting of the legal committee. Begin with roll call. Claire.
Here.
Jenny. Here. Jason.
Here.
Morris. Here. Isabel.
Here.
So we have just two items on the agenda this evening. The first is relating to the short-term rental law. I need to put up here. So this is a very narrow issue. Personally, I am very much in favor of regulation of short-term rentals, and before I was on the council, submitted many proposals to the council at that time on how to regulate in such a manner that neighborhoods are not decimated. However, in the last couple of years, there's a specific piece of language that allows residents who live here for at least 50 days of the year to rent out their homes while they're out of town. And a number of people had approached us, different people on the council, asking that the 60-day maximum per calendar year be increased. And so it came up a couple of times. I thought, bring it back in this administration, take a look at it and see what we want to do. When I was looking at this last year, one of the things that struck me was that there is no provision in this paragraph that requires that if you're renting your home while you're out of town, that you designate a local contact person. And most municipalities, that's a requirement. It was not addressed, I think, in this local law because in general, the short-term rentals that are rented out throughout the year are done so on platforms where there's a co-host arrangement, typically. And this was probably just left out. And many of these scenarios don't necessarily get posted on a platform. It could be word of mouth. It could be an acquaintance, a friend of a friend. So I wanted to make sure that that got added in. I also met with Michelle Tulo, who oversees the rentals, to see exactly what are we talking about here? What's the scope? In the last year, she looked at a 1-year time frame. 13 residents took advantage of this particular provision. Of those, most were renting in the 15 to 30 day range. So this comports with individuals who are going on vacation and renting their homes out while they're on vacation. And there are only a couple who were close to the 60 limit. There are some people who are not yet registered, that there's a process to get to notify and to get people registered who are using this, but again, small numbers. My personal opinion is that for a couple of residents, it probably is not worth the effort to discuss changing the maximum limit because it's not going to impact very many people. But I do think we need to put in add the provision that if you are renting out your home while you're away, you must designate a local contact person and provide that information both to the Hudson Police Department and to code enforcement in the event that some issue arises. So that's what we've got on short-term rental. Comments, observations?
I guess the question that I have is like, before we consider extending the days, the enforcement looked like since we rolled
Well,
up.
I just thought that.
I heard what you said.
should.
Yeah, and I'm asking what the enforcement has been
Well,
on top of that.
The enforcement process, this is a self-report situation. Given that most of the people who are using it for very limited periods of time, I think that they're probably in compliance. But this is really a case where if you live next door to a residence that you think is being rented out more than 60 days a year, or it seems to be always rented out, that you would notify Michelle or you'd notify the city. But that's really the only mechanism they have for enforcement.
Thank you.
Should something about that be written into the law?
I don't know that, what would you write in, that people should notify? You can't really ask people to do that. You can't compel people to report. I mean, they should.
Well, there's no way of knowing for the general public who to report to. It's not written anywhere. This, what I'm getting at, I guess.
Well, I think
That's why
You know,
we're,
people-
we're concerned.
Right,
We
but
don't
people
know.
do complain. And that's how Michelle gets notified of something that's not registered. And there is a process where they get notified by,
I would
treasurer's
never
office.
have known that Michelle was the person to notify.
so maybe we ask the mayor's office to put something out on the website, making it clear that for any issues relating to short-term rentals, that they should contact Michelle Tootle. She has an assistant, a part-time person who works with her on this. She gets monthly reports and so forth, on the other short-term rentals.
I know there are other municipalities that require people in short-term rentals to notify their immediate neighbors.
Right.
Of it, and then in a conservation file if there's an issue. You know, it's legislative choice, but able to do that.
I had heard very similar things to Margaret about the numbers, and I felt the way you said it was exactly the way I was feeling. Since we are adding this piece right here, which I do think is a good idea, we could add contact information. We could put HBD and code enforcement phone numbers in this spot if we wanted to,
Okay, that's fine.
or, and even add them at.
Yeah.
Michelle Toole. It limits it to changing one spot.
Well, if you put it in here, then you're only putting, well, I agree with you on HPD and code enforcement for this specific thing, because that's not part of the rest of the law. That's the law is much broader. Anything relating to short-term rentals should go to Michelle. And I think the best place to notify people of that is on the website.
Okay.
Because that would apply to, just the ones that are rented out throughout the year.
So that's a good idea, just add some phone numbers to this line, and I think I like it very much.
So we will send this from here to the informal, and then we should be able to vote on it in at our formal meeting later this month. And that's all I have on short-term rentals. Okay. Oops. No, don't say. So the next thing, and I just put two things on the agenda for tonight because I want to allow enough time to discuss. We have received a communication from a resident, Strites, ask with a proposed local law amending chapter 325 of the city code. This relates to dock usage and the language in the code relating to the status of the usage in 2011. So Donna has come here this evening to talk to us, and I have also met with her to go through all of this. Do you want to speak first, or shall we hear from Donna to have her give the, yeah. So Donna, do you want to give us a summary, like no more than 10 minutes of the main thing here? We did have a local law that was considered last year, the last administration. And the numbers that were used in that came from 2015. This particular one that you're proposing uses data that you identified from 2009. So just walk us through your research, how you came up with that, and why you think that is appropriate information for 2011.
Okay, I'd be happy to. I have 3 sets of handouts, if anyone needs paper handouts.
It's printed.
Jamie? Mind that.
I don't need anything.
Okay.
You need anything?
And would you like? Okay, thank you so much for having me here tonight to speak about this. In an effort to clarify City Code 325-17-1D, I conducted some extensive research to determine the level of dock activity in 2011. I researched city and planning board records. I also conducted a FOIL request of the 2009-2010 Greenport Planning Board review of ONG Industries application for a site plan permit to designate the old rail bed into a truckway to truck aggregate from the quarry to the dock. At that time, ONG was leasing the quarry and the dock from Folsom. The results of my findings are summarized in 2 charts, and I'd like to walk through those with you at a high level in a moment. and I'd be happy to answer any questions that you have. Bottom line, the local law clarification from last year was updated to reflect dock use limits that are closer to 2011, greater than the limits in 2025 draft that we saw before, and are based on an independent professional assessment of truck activity at the dock during the time that the LWRP was being developed, 2009 to 2011. I'd like to refer to the charts. There's 2 pages stapled together. I'd like to look at page 2 first. It's
What's it look
titled
like?
Waterfront Dock Use Timeline.
Okay.
So
It's this one, Logan?
this provides a chronological summary of the dock ownership, permitting, and truck studies from 1977 till 2020. And you'll note that travel from the quarry to the dock really didn't begin until 2006. O&G began leasing the dock and quarry from Holcim in 2005. They began trucking in 2006. In 2009, O&G applied to the Greenport Planning Board for site plan approval, as I mentioned. And as part of that review, they hired Creighton Manning to do a traffic evaluation study. That was completed in January 2010, and they updated it in February 2010. They subsequently withdrew their application on or after September 2010. And you'll note in the bottom row, annual truck trips in 2009, based on the Creighton Manning studies, equated to about 10,800 trips. That's to and from the dock. And it was during this time that the LWRP was being developed. For example, the 2009 draft generic environmental impact statement was in development at that point. From 2010 until mid-2014, level of truck activity is unknown. Mid-2014, Holcim decided to divest their Hudson and Greenport holdings and transferred ownership to A. Colarusso and Sons. They began trucking mid-2014. 2015 was the first full use of trucking, and the annual truck trips that year was 5,460. And that number was determined based on the 2020 Creighton Manning truck study. Colarusso hired them to conduct that study. Any questions on this?
Why annual truck trip?
Why annual? It's a good metric. They don't run trucks every day. They may, in fact, I don't have the exact numbers off the top of my head, but from 2015 to 2019, based on the 2020 Creighton Manning study, Colarusso could have operated up to 365 days a year. One year they were only a little over 100. One year they were closer to 200, so kind of up and down. So the best metric in terms of volume of activity for the year is an annual limit.
Be totally clear, in 2009, when it says up to 10,800, it's 5,400 in, 5,400 out.
Yes,
The 50, and then 2055 be 2,730 in, 2,730 out. That's
Correct.
what
There's one thing also that I just want
Yes.
to mention. And it's in your other document.
Yeah.
The actual numbers that CME Creighton Manning cited for 2009 were up to, it was tonnage, is what they cited, not trips. 148 tons of aggregate. And how many barges were used, 27.5 tons per average truckload. And that is where the number that is used in this revision
right.
comes from, because they didn't actually talk about number of truck trips, they talked about tonnage.
Exactly. So,
Can I step in there?
sure.
Okay, so that same report, under B on page 2, trip generation. There is a section that does refer to truck trips. One truck and all 2 loads of aggregate per hour. Equates to 4 trips, 7 trucks running 7 drivers, 28 total vehicle trips per hour. 385 tons of material moved each hour. So that's the same, it's the same document.
Yeah, that is the document. Those numbers, I'm not an engineer, so I can't explain how they come up with those numbers. But they're trying to measure truck traffic flows and intersection with traffic, crossing highways and whatnot. But what I'd like to do is walk through the second document.
Okay.
On the website, it's titled Existing Uses in 2011. So this document summarizes the results of my research. There were 5 findings, and I'll walk through each one at a high level. First row question is, what was the activity in 2011 by ONG? And the data appears to be unavailable. The Hudson Planning Board records include an email from ONG Industries to Acal Russo and Sons dated April 30th, 2021, informing them that 2011 truck records were not available. They were destroyed in 2019 based on the company's record retentions policy, which is standard. After 7 years, records are typically destroyed. So they don't exist. Point 2, the November 2009 LWRP draft generic environmental impact statement report makes references to 80 round trips per day, 400 per week in a number of places in the report, but there's no source cited. There's no substantiation of the data. Where did this come from? I believe the source appears to have originated from an informal statement from ONG's engineer, and we'll talk about that a little bit later. In 2021, the Hudson Planning Board conducted, as part of their seeker review of the dock and haul road permit, they conducted an environmental assessment form part 3. And in that document on page 1, footnote 3, they reference this 2009 DGEIS report and the 80 round trips per day, 400 round trips per week. But again, there's no source cited. Point 3, the third row. That same report, the EAF part 3, the Hudson Planning Board extrapolated that 80 trips per day, 400 per week to 35,200 trips per year. But it's not based on real world data. It's just, and it's not referenced anywhere in the 2009 DGEIS report. They simply took 400 trucks per week times 44 weeks, the estimate of the barge season times 2 to and from. But again, it's not based on real world data. Point 4, the last row on page 1. Based on my FOIL request, I obtained the January and February 2010 Creighton Manning traffic evaluation reports. These are independent professional assessments of truck traffic volume to the dock, and it quotes, barging operations have recently transported 148,000 tons of aggregate in 1 year. Now, these Creighton Manning reports appear to be the last independently determined professional assessment of the level of truck activity predating the city's adoption of the LWRP in 2011. Now, a couple of points. During this time, the Greenport Planning Board was conducting their review of the ONG site plan permit application. The LWRP was in development. The 2009 DGEIS report was being drafted. Secondly, the Creighton Manning traffic studies provided professional estimates of the volume of transportation activity from the quarry to the dock in 2009. Specifically, and the numbers shown in the second paragraph from the bottom on the right on page 1, these are specifically cited in that report, up to 148,000 tons of aggregate moved by barge, an estimate 45 barges used, 27.5 tons average truckload, 3,300 tons typical barge capacity, etc. From those numbers, I was able to derive the estimated annual truckloads of 5,400, that's rounded, or 10,800 truck trips back and forth. Now, in the draft local law clarification, the number used is 5,382. And that was derived simply by taking 148,000 tons divided by 27.5 tons per truckload equals that number of truckloads, round trips. And if you multiply that times 2, that's the back and forth.
And if you keep going with those numbers,
Yeah,
I found somewhere in there 39 weeks in a year. You mentioned 44 a minute ago, but. So that's 130.
so actually, I'm not factoring in number of weeks here, it's simply,
I am.
it's simply 148,000 tons at the time divided by,
Okay, I'm trying to work all the way down to number per hour.
oh, okay,
So in this case, if it was 39 weeks, which is on the conservative side of the schedule, that's 138 trips per week or three and a half trips per hour. I just want to put that out there.
okay. So, oh, and then lastly, on the flip side of that page, the question of the source of the 2009 DGEIS 80 trips per day, as I mentioned, I think that's based on an informal statement made by ONG's engineer. In the FOIL review, as I reviewed the Greenport Planning Board minutes, one of the meetings, January 25th, 2010, included an exchange about truck volume. And included in that exchange, Pat Prendergast, who was the ONG engineer at the time, stated not more than 14 trips per hour or 80 per day. So I'm thinking that's probably where that number came from. It ended up in the 2009 DGEIS. Any questions on that?
No, I think, the reason this came up last year was because the language in the code had a statement, any type of non-conforming use shall not be enlarged, extended, or placed on a different portion of the lot or parcel. Nor shall any external evidence of such use be increased by any means whatsoever. Any activity that caused an increase in external evidence of such dock operation became non-conforming was unauthorized and unlawful. So the problem was that it just said nothing beyond 2011. And so the clarification that was put in what we looked at last year, in the last administration, basically reiterated it has to conform with what was in effect in 2011. And in the event, because the planning board doesn't have any guidance from that general statement as to what that volume is. And so the clarification was using data from 2015 from Colaruso's study. And that's where the numbers that were put in there were. So I think, I think the work that Donna has done, I do think putting in clarification is important, first of all. And I think that what I'm looking at here has a lot more validity for me because temporarily it's closer to 2011. It was done, the report was completed in 2010. The previous owner was up and running, if you will, at that time in 2011. The numbers from 2015 are from when Colaruso was gearing up in their usage of the dock. And so I think understates what the volume was that they were going to be gearing up to. So I think that using the 2009 data for clarification to me is much fairer to Colaruso because it reflects a kind of fully active dock at that time. So that to me is a compelling argument for using those data. But I do think some clarification about how do you quantify what is meant by the activity in 2011 would be helpful to the plan.
Okay, I have, two responses, the, to say fair to Coalition, the reason I did that math is currently they feel like they've been approved for hundred and 42 trips a day.
Oh,
140,
excuse me, could I comment on that?
No, hang on.
Okay.
You're welcome back to.
so this is substantially less, so I'm not sure the word fair would fly very well. I'll go back to what I said before about the Creighton Manning document that is attached. The
Are you talking about the follow-up or the original?
the one that I mentioned to Dawn a minute ago, the same document that she calculated her numbers from, has numbers that more relate to the 142 trips. And the data supplied by the applicant is exactly what it says from 2010. So that's
Can you cite the page? What,
so page 2 of the Creighton Manning CME
is it the January?
document.
The January 5th?
It is
Yes,
January 5th, 2010.
Yep.
Page 2, letter B.
Mhm.
That, it feels to me like the numbers could have been chosen from that section as easily from any other section. And then, so those are my 2 points directly to what you were saying. But I think maybe it's important for us to, I think we skipped over what we're trying to accomplish here. What is this? Why are we doing this? And maybe stating,
Okay,
what
so,
are we trying to accomplish?
okay, what we're trying to accomplish is that the code of the Triton just directs the planning board to say that it can't go beyond what was occurring in 2011. But it doesn't give any guidance or any quantification to the planning board as to what that means. And so the attempt last year, before this other research was done, came up with, well, we have the 2015 data, so that's what was used to say in the event, so in last year's report, in last year's suggestion, for purposes of determining the baseline use of commercial dock operation that such existed as of effective date, that's in the code, as required by subsection 1, shall constitute the maximum parameters of a conditional use permit issued pursuant to 32517. Planning board shall, to the extent reasonably feasible, determine and apply the following metrics: annual traffic to and from the dock parcel, tonnage of stone and gravel. Now, given that there wasn't any quantitative data for them, using the 2015 information, clarification was added to say, to the extent it is found to be infeasible to make one or more of the specified findings with respect to baseline use of commercial dock operations, as directed by subparagraph A, planning board shall apply the following metrics. And that's where those numbers came from. So I think there is value to whether the numbers in what Donna prepared are not the right ones, we can talk about that. But I think there's definitely value to putting something in place that gives guidance in the event that it is infeasible, which it is, to exactly say what the level of activity was in 2011. So
Okay.
I think we can talk about what the correct numbers are, but
I don't think that answers what we're trying
no,
to accomplish.
I've just told you what we're trying to accomplish. We're trying to clarify so that the planning board actually has concrete information as to what the level of activity was. The conditional use is supposed to not go beyond what the activity was in 2011. And
Okay,
yet there's no quantification of what that activity was.
okay.
That's
So the planning board has already ruled on the whole road. They have ruled on the CUP. Did they ask? I mean, like, I'm not sure. They haven't asked for clarification. Like,
Do you want to speak to the issue of, this gets to conditional use and whether or not, you know. you
Yeah,
can-
well, the issue would be if the court remands it back to the planning board, because one of the questions was the conditional use permit didn't refer to the provision of the law that says that it's like, sorry. I said the question would be that if the court remands it back to the planning board, because the planning board's conditional use permit didn't address the provision in the code that says that conditional use permit may be granted for dog yards, blah, 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 as such use existed in 2011. If the court says you didn't do that, you do need to do that, and it gets sent back to the planning board, then they're gonna have to answer that question. So the issue here is, if it gets remanded to them, they have to answer that question. Is it just, are they gonna have to figure it out on their own? Or is the common council going to provide the framework that tells them how to deal with it? But if it gets sent back to the, it may not get sent back, we don't know,
Right.
but if it does, they're gonna have to answer that question. And it's a matter of, you must leave it in their hands and let them figure it out, or are you putting something in that's based on this, or, whatever. But that is the reason that this would be relevant, is that if it gets sent back there and they're compelled to, don't know that that's gonna happen, but the court could order them to, where it says as such use existed, to say what that means, and they would then have to figure out. So that's could when this would come into play.
Could as such use existed be interpreted to mean trucks arrive with gravel, dump gravel, load gravel on barges, trucks return? Does it have to include volume? Is there anything?
Well, this is part of what would need to be resolved. So I can't answer that question because that would be the question, and the board would be.
For-
Well, there is language though,
um,
that says, that any type of non-conforming use shall not be enlarged, extended, or placed on the different portion of the lot or parcel occupied by such use of the effective date of this chapter, nor shall any external evidence of such use be increased by any means whatsoever. That's
That does not necessarily mean volume. And that's why I ask about annual volume, because no one can perceive annual volume. I think it's much better and more accurate to be talking about either hourly or daily trips, because that you can actually see. And the other point that's main in my head is that there's a lot of focus on volume, whereas I think what people are trying to mitigate is issues like noise, dust, pollution. Can we focus on what we're trying to fix?
Well, the volume is important because that's, we had a whole discussion about this last year about the roads being destroyed. And so the weight of the volume of,
Well, when they were traveling on mostly our streets, now they
Right.
call us two highways.
If I can clarify, I think
And
I think the reason that it's being addressed, proposed to be addressed this way now, is because the question is not, this is not at the beginning of the review process where all kinds of things could have been modified. This is taking place within the context of determination that's been challenged on a particular point or two. And so if it gets sent back, it's unlikely that it's gonna be sent back for a redo where they're, looking at conditions and all these other things. I think it would be, if it were to be sent back, the point that was raised is it's gonna be sent back to answer the question, how do you make this conform to the 2011? So that is really the only thing probably that can actually be reconsidered if it gets sent back to the court, even though these other things maybe have been, if they had been more, clearly laid out in the code a year or two ago or beyond. But right now, it's unlikely that this is if it were to be sent back at all, would not likely be sent back for a total redo. So basically the purpose of this law would be to provide a way to answer this very specific question that the board would have to answer, which is if the court says, it says gotta be as of 2011, what does that mean? It's only things that would answer that question that would really be relevant here.
under that scenario and this law as it's written, we could have 142 trips a day until the annual volume is met. That's what it appears to me, and I don't think that answers the needs or the concerns of the people that are interested in.
You're right, that could be the way it would work out, because as it's written, it's just the total number doesn't address the distribution of them at all, so they could be all focused in a short period.
So I'd like to make a suggestion. So the reason this is, it came as communication. I decided it should go to the legal committee for review and discussion, which is why we're discussing it now. Before it goes to the full council for consideration and vote. Do you want to propose revisions to, by the way, one revision that if we do put something in place, I would like to incorporate language from the 2025 version. Because I think under the legislative finding purpose in that document, there was some very valuable information. I would like to incorporate that into any new version of the law. But do you want to propose different quantification for my consideration?
I appreciate the offer. I think I look at the issue just not as a volume issue because,
Oh, I get that. I understand.
yeah, and I think it's an issue all around town with trucks. So I'm more interested in amount of pollutants, amount of dust, amount of noise. And I think there are entities, we patrol noise on our own, or we enforce noise on our own. Our code enforcement officer would do that. I think, DEC and EPA control pollution. I think they do it through truck, they require apparatus on the trucks that deal with it, but if there is an issue with pollution, I believe they'll address it. And so I just think the approach of volume is missing the point. And so I don't know that working with this and working with volume, that's something that fits with my thinking.
So if you don't want to approach volume,
If someone does want to approach volume, I'd rather see it on a daily or hourly
Okay.
basis.
okay.
Well, again, the question is, as it exists, everything,
That's fine,
if
that's
it's gotta be anything that's actually sort of enforced, it's gonna have to be tied into
It's here.
tying
I
it.
don't,
Why,
why
no, I'm just saying. Right, but like, when you talk about police and stuff, unless you can monitor. To make it, you know,
So,
what can you tie back to 2011 is the question.
okay, well, if Margaret's offer stands, I would use that paragraph to calculate the
No,
number.
it does stand, because the purpose of having this at the legal committee for discussion is so that we can talk through these things and come up with, okay, do we want to make some revisions? Do we want to make some recommendations before we move it to the full council? Full council may or may not even vote on it, but that's the point of having a committee is to, as a work group.
Okay, then I would, sure, with these numbers.
I'll send you a word version.
I'd like to run through a few.
We do have, yeah. Can you hold one moment?
Yeah.
John has just identify yourself,
Yeah,
not
sure.
necessarily by name, but
Yeah.
connection to.
Josh involved, former common council member. I just want to give very quick sort of my background to tell the very reason why that law that we're trying to put here, hopefully to clarify, even came into existence. It was because of the massive, some of you are not in town then, but the massive public comment that came to inform me of WRP was about controlling the intensification of waterfront industrial activity. It was a massive public comment. It's the whole reason the zoning law came into effect. So unfortunately, at the time, that the council didn't draft zoning to clearly speak to this issue that you're all talking about here. But it's clear that the language speaks to intensification of use. And that is, in my idea, as you're talking about volume and annual volume is a very good way to approach that. Whether or not a truck could go there 200 times in one day, whatever it takes to approach that line, that's a very good metric. Furthermore, there's no guarantee that Kohler Russo, they run a great business. People like them a lot in this town. They're very proud of what they do. They might not be the operator here in the future.
Correct.
And if there's no sensible approach to address that overall volume of activity at the dock, it's going to blow a hole in the future economic activity in this town. People desire to live here, quality of life, the waterfront. It's adjacent to a park. So quibbling here and there over different issues, rather than focusing on what the intent of the law was, what the intent of public comment at the time informing the LRP, I think it's important for the council to think of the law in that respect. And not think of it as a trying to punish or being more fair or betting too far to one which business or not. It's about the future of the city. It's about writing a good law and addressing what the public wanted at the time, period.
So actually, and then I'm gonna come back to you. I forgot to mention that, the issue that this could change hands and in the future be a different entity. I think that's really, really important. Because then we're gonna have, we can have a situation, and I'd like you to speak to this, we can have a situation where, whatever Colarusso, the current owner or whoever it is, whatever they are doing at the time of sale becomes the baseline for a future entity, when actually the code says, no, you can't go beyond what was going on in 2011.
And if I could just add one more thing really fast, and I was very intimately involved in a lot of the presentations that Colarusso has made about what their activity is at the dock. From the beginning, they said that what they're doing is not intensification of use. They have no plans to grow their business. They would say these things repeatedly in public. So they had to have some awareness that the 2011 zoning, which they bought the property, affected their plans of use there. So I'm not saying whether or not so that should just come into mind that this is about long-term use. It doesn't necessarily mean them, but if they choose to sell it, it presents a big gift and something harder to control for the city to choose to say, well, we need to balance interest between industrial activity, recreation, and other businesses and waterfront. You lose that chance.
Well,
Can we defer to Ken one more thing?
I'd like to respond to just one thing. So I've heard unlimited intensification. There is a limit. There is a limit. The planning board set a limit of 142 trips a day. So it is. And I go back to, you mentioned there is a real goal that people want. The neighbors have talked about pollution, dust, air quality, noise. And I don't think,
No,
I don't think we're addressing it.
No, we're not, and I certainly submitted documents on those very topics to the planning board, but if it comes back for reconsideration, the planning board chose not to put anything in place to monitor or mitigate pollution, air quality or anything else. They said that couldn't be done, despite the fact that they were given documents that showed that it could be done. So no, I don't disagree with you on that. Oh,
Yeah, well, let's take it back. If it's sent back to the planning board, I mean, to some extent, the horse may have left the barn on a lot of these things, because that's why, in all probability, the only question that would come up is if there's, again, when it says as of 2011, what does that mean? So a lot of these other things would come up more timely back before they may be irrelevant because they may be not permitted to reconsider any of the other things. But that's why I think this was focused on that one question, that because if it does get sent back, then that is the question they're going to have to answer. And so whether you leave it entirely up to them or you give them guidance it's totally up to, it's entirely up to you as a legislature to do that. But that's really what the issue is if they get told they have to address that point of law in the code, how are they going to do it? You're going to help them really to their own devices. But anyway, I want to go through several things because, Hollywood's attorney, DJ Ring, put in a letter when this came out and referred back to the October 25 letter. He raised a lot of points that are going to take very serious consideration. And some of them actually, they cover a lot of points. And there may be more merit to some of them, and there may not be merit to some of the other ones. But each one of them really is going to take a very thorough analysis. Some of them, well, for example, I think there's some local issues and there's more extended issues. Like one of the things that they bring up is the question of whether this, impairs interstate commerce, which is a complicated question. And that's something that wasn't in front of the planning board, and it goes beyond just the local zoning code. And that's going to be a very significant question to address. And in fact, that could be governing. It could say, well, it just would be wrong. You can't do this because of interstate commerce. I don't know the answer to that at this point. Some of them, though, that they bring up, I think there are answers for it. And there are four fundamental things just wrote this thing up. I can give you copies at the end, but there are four fundamental things that kind of set the foundation for where we are right now. One is the dock was designated a non-conforming use in 2011 by Local Law 5, 2011. So that's important because non-conforming uses have very different legal rights than conforming uses. There's no question that it was non-conforming use, everybody acknowledges that. And it said non-conforming uses can be regulated, limited, or even eliminated by the municipality. There's lots of case law on that. If something is a non-conforming use, not that I'm doing it, but it's important to understand that the outer limits of what a municipality can do. There is a process that they call it amortization, although they acknowledge that's an improper term, which is a non-conforming use. You can put an actual end date to it, although it has to be reasonable and essentially allow the owner to recoup the investment they made or most of it. That's a case-by-case, fact-based thing, but the point being, a non-conforming use is not necessarily perpetual. It's not a perpetual right like some other things. And
So if we want to, we can eliminate that use.
in theory, you could. The conditions for doing it might be quite extensive. It might be many years. The point is, you're not. It would have to be in such a way that they.
Clarence, something you said eliminate Colarusso, right?
Excuse me?
You said eliminate Colarusso?
No,
What did you say?
eliminate the use.
Oh, sorry, thank you.
In theory, the law could allow that under the right. It would have to be done properly, but over enough time that they would recoup their money. But the point is, it is not a perpetual right. It's not, you can't do it immediately. So they've pointed out a number of times that they have a vested right in the dock, and that's true. When the dock was first designated a non-conforming use, it would have been entirely unlawful to come in the next day and say you're shut down. It's unlawful. It's a non-conforming, you got to shut down. There was a vested right that existed at that time to continue to operate that dock. But the thing that, because it is a non-conforming use, it is not a perpetual thing, and it can be wound down in time. So again, nobody's proposing doing that, but it's at the outer limits. So to a lesser thing, which involves some limitations, is a less dramatic and less impactful action than actually elimination, which is the outer what can be done.
Why don't we put limits? Why is the planning board?
Can we hear out the points?
What is it?
I don't
Okay, so
hear this first.
Oh, did that, sorry.
then non-conforming uses are regulated by section 325.29 of the Hudson Code to prohibit any increase in the external evidence of use. And so when it was designated a non-conforming use in 2011, became subject to the condition that no external evidence of that use could be lawfully increased from that point. That's just the logical following from the existing, and that provision was in the code a long time before any of this happened. So that was the condition that became effective upon the parcel when it was made a non-conforming use, that it couldn't, that no external evidence of the use could be lawfully expanded or increased. Then Colors bought the dock in 2014. It's 3 years after it had been made a non-conforming use of it. Upon their purchase, it was immediately subject to all these things. Hudson Code 325.17, which provides for conversion of the non-conforming dock operation to a conditional use, provides that a conditional use may be approved for continuation of existing commercial dock operations, and there's more detail, as such uses existed on the effective date of this law in 2011. So the authorization to issue a conditional use permit continues the limitations that existed when the dock was designated. I think there's one thing that's really important that has been lost. Some people are treating this as imposing new conditions, but that is not actually the case. The condition was imposed on the dock as a non-conforming use in 2011. That no increase in external impacts or external evidence could occur. And that was before we got it. And then that condition, that limitation was continued at the time of the conditional use because it says it can be conditional use as such uses effective 2011, which brings you back, everything goes back to the same point of 2011. So the conditions have been in effect on this parcel since 2011. And so this law proposed does not create a new condition. What it says is you're still subject to those conditions. And here's a way, so when the planning board, if it has to go back and make sure that it does, this is what you're looking at. So because this law fits into this framework and because it seeks to provide an answer to questions that would have to be answered to properly carry out the law. And those essentially, what objective standards should be used? One, to measure the level of external evidence of the use that existed in 2011, which the operation is not allowed to increase. And two, what standards should be used as the baseline to evaluate conformity with the requirement of the use now and in the future as though it has such use existed. That's the questions that would have to be answered. And this was proposed to help the planning board answer them if it needs to. So that's kind of the framework of the law. Now, there are a lot of that's sort of the superficial, context and structure of the law. A lot of the issues that they raise are very important. They don't get at these, that line of logic is pretty solid. So, but what comes up is their arguments, which really do need to be deeply evaluated, is, they are arguing that it's, when they talk about their vested rights, but I said that it's probably something that is not something that can't be addressed by this. But I think that when they talk about interstate commerce, that's something that really will have to be very, very carefully. If that could preclude this whole thing, and
So how do we address that?
well, there's case law and that'll have to be fleshed out. I mean, I've never advised the board to do anything that got them in any trouble. I've never had any board have anything that followed me overturned by a court. I'm very cautious about it. And so this takes some serious inquiry. If it looks like that's a valid claim, I will no hesitation to tell you that's my view. But there are things in here that need to be very seriously considered. And but there are some things that are in here that I don't think hold much weight at all. Another one, for example, that the code does talk about 2000. It's very clear about 2011. They may have been doing a lot more than that since then. Maybe they have, maybe they haven't. It actually doesn't matter, and that doing more doesn't establish any further right than what was in the code. So. And, I did find some cases on that point that basically municipalities never stopped from enforcing a zoning code. So if you have a zoning code that says a certain thing, even if nobody's followed it, even if building permits have been issued accordingly or erroneously or not in compliance, at any time, at any point, if the zoning code provisions they're still valid and applicable. So if these provisions are in effect, the actual use, whether it's more or less in the intervening years, does not establish rights. So, when they talk about vested rights, they are right that they did have a vested right. And at this point, they still do because there's been no amortization. So they definitely have a right to be operating. But it is not complete if that were to imply that it gives unlimited or endless rights. So, they've got a lot of points in here, and they're quite complex. There are a lot of complexities to this law. There are other issues that come up that, what can be limited? What sort of items can be restrained? I mean, there are principles that when they're stated are kind of vague, but about not zoning, not regulating the internal operations of a business. But that does contrast with the ability to put restrictions on external impacts. So sometimes there's you might not be totally clear with what you're looking at. So there are questions about whether these specific things proposed to be limited are subject to limitation. The fact that it's specifically in this codes, sometimes there are just general terms in codes. And if the thing increases the number of things happening or sort of that may not be something that can be restrained. But if there's a specific, very precise and specific code provision, that may govern. So there are a lot of things where there's an argument on this hand and an argument on this hand. In the end, one of them prevails, and usually the specific prevails over the general. So there are a lot of big picture questions that they've raised that really do warrant very, very serious consideration. And I'm in no way able to give definitive opinions on a lot of them at this stage, but they're serious things. So there's kind of two levels. One is like the fundamental authority to do all this stuff. At the immediate zoning level, I think it's very clear from the 2011 non-conforming to the conditional use to now that it's not putting in a new limitation, new restriction. But if it's enforced, part of the question would actually be the validity, a lot of the questions they raise speak more to the existing laws that are already in the books, because they're the ones that put these things in place. And if those laws are manifest through this and the next steps, some of these questions might arise. So some of the issues may relate more to the stuff that's already in the code than what's actually in front of you right now. It's a very complicated question. It's a lot of questions. It's a very difficult thing, but all that can be done is to look at them very, very seriously and see if there are things that would preclude doing this.
But what I'm taking from what you're saying is that we should do more work on this and discuss it.
Well, there are two things that can go on kind of in parallel, which is one is perhaps shaping, if you want to make some modifications to law or revise some of how you go about it, you can go ahead and do that. You can introduce the law when you're ready, and get the process going. A lot of the review can go on concurrently. So, you don't have to wait around until everything is answered. You can start, in fact, you probably want to get a law that you want to work with, get it introduced. So there's actually a concrete thing to see how those provisions measure up against some of the questions that are raised. But it does have to get to the point where it doesn't run afoul of any of their constitutional claims or any of the other things. And I can't say now whether it will or won't.
So, in your opinion, do you think that we can come up with a version of this law to introduce to the full council, not to vote on, but just introduce to the full council in this month, and they continue to work on it?
It certainly could. This introduction is very preliminary. It's a way to get the ball rolling.
Right.
You don't have to do any referrals on at that point. You can modify, you can amend it. You can let it die, you can vote on it. But it's a good thing, first step. It's not binding. It really is just, it can be introduced. Even introduce a law in a very cursory way. It doesn't really have to. So if you want to get something out there, it's like that lets people have a hard and fast thing to look at, to make comments on, to address, and the specific concerns can be addressed in relation to specific provisions and work from there. It's probably not a bad idea. Get it going. It could take, and I can't say how long. It could be resolved reasonably quickly. It could take quite a long time, but it doesn't hurt. And not everything gets introduced even has to be voted. It gets to the point where it's like, no, this isn't going to work out, and just let it die. But I think introduction is just a first step so that everybody's got something to clearly work with. And you can freely amend it all the way through the process.
So, is it committee comfortable with, we'll work on some revisions here. You can give me some revisions. We can introduce the draft.
I'm still questioning whether I should or not, because I'm not sure that I believe in it enough. I think maybe someone who believes in it more, if someone does. I would like to hear what Jenny and Claire think. One thing that I did say I would do tonight, just to make sure it's out on the record, is, and I talked to Ken about this. Ken has written a number of letters to the planning board on this issue. He had litigation as the attorney for the city of Hudson years ago, against Colarusso. So he has a long history in this. I think if I don't know, I'm not an attorney, but I think it has an impact. If we get into a lawsuit, I think it could be mentioned. I think Ken feels differently, but I think it needs to be known that Ken has a history with this.
Yeah, I've been involved from the very beginning, because I was the city attorney when the first action working on the bulkhead, the trigger, all this got started, and I was involved early on. And what, in 2017, others have sued the planning board to try to, didn't want to go through somebody review, it was an expensive thing, and I defended the city. Successfully dismissed all of their claims. I have continually, and what happened after that is I was no longer with the city. And after when the case decision came down quite a long time later, I wasn't with the city anymore. And I thought I was long done with it. But what happened is that their attorney, John Privatera, went back to the planning board and, in my view, completely misrepresented and distorted what had actually gone down, completely misrepresented what the court had said. And I, after having done all that work and defended the city and the law and the code, I was frankly angry that someone was taking all that and throwing it away with, in my view, was complete misrepresentation. And I put in what I believe to be clarifications solidly based in the law and the decisions. And, it's like, I wasn't trying, I've never, ever taken a position on what the planning board should have done or argued for or against any outcome. But I put in a lot of things to clarify what the law said.
Well, the introduction of your letter specifically said that you were not taking a position on.
And also, I did this entirely on my own. I've never been hired by anybody to work on this stuff. I've never taken any money for it. I was trying to defend the law of the city of Hudson when I thought it was being trampled upon. So that was what I've done. At this stage, though, what's also, I think, very significant here is this. What is being considered here is a legislative political question that I have no say about or influence about. It's like it's going to be your political decision about whether to do this. If it's different from, say, a judicial thing where, like a planning board or a zoning board, it's a question of, it's almost like a jury. This has nothing to do with it. You can do what you want or not do what you want. So I don't really have a role in that. That's the outcome of this thing is a pure political legislative action.
Personally, I think
Doesn't solve me.
Ken's background in this is a great strength for us because, as he says, this is a political decision for us to make. And the fact that he has so much information and detail and has in fact represented the city on this topic in the past, to me, I see that as legally a great strength. And then we make our own decision as to what we choose to.
Yeah, if there are any legal questions, I've never never guided anybody to have anything that was ever overturned by a court, and I'm in no mind to change that record. If there's a thing in here that I believe puts you afoul of anything, you will absolutely hear it from me, but it's a complex question. And I think it goes back years and the law and the origins, and I think somebody's thinking questions that come up to people, they don't know some of these origins. I know there are people who have answered questions when they were without incredibly fundamental information that is accumulated over time. But it's, I'm, you know, my master is the law. Yours is the decision and the policy. You know, it's immaterial to me what you decide to do, as long as it's done within the constraints of the law. And as an attorney, I think that the guidance usually should consist of one of the three things: advising what you cannot do, advising what you must do, and everything else in between that you may do. And within those two confines, what you may do, I have nothing to say, you know, and that's totally up to you. And that's where most of the things happen at the legislative level. It's, you know, it's different in other administrative things in the mayor's office, and there's a lot more of what they have to do or can't do. The legislature, as the legislature, most of what you do is just simply, yeah, you can do this if you want to. You don't have to, but you can. And it's a discretionary choice on your part. I've never, in none of my places, do I ever try to make recommendations or push people one way or that's just not my job. So, you know, I'm trying to bring the knowledge and the history, but I'm not interested in suggesting you do this way or that way. That's just not my thing. So.
Jenny, do you have any comments?
I liked your point about the reason for doing something. If we're going to change this, I feel very confident in Mr. Dow's history with this. And he can guide us if we're doing something that we could potentially see ourselves in court over. My only question is, because we don't have any data from 2011, we've had suggested data. I don't know, it requires a little more conversation.
That's actually a good point, and that's not what I want to mention. You don't want to be in a position of doing something that's arbitrary.
Mhm.
And I've started to look into some cases. Obviously, there are times, not just here, but there are times in the administration of law or whatever, where something has to be decided where there is not complete, thorough, accurate data. So I've started to try to read cases like what is considered acceptable or lawful in those circumstances. A lot of them have to do with taxes, which are, you know, shed some light on it, but that's going to be an important thing. I mean, arbitrary primarily means pulling something out of thin air without any basis. This has numbers that people are trying to get in close proximity they can. Is that sufficient?
Mm.
I don't know the answer to that.
Mm.
And I'm going to try to do the best research I can to find out, is that sufficient? You know, it may or may not be, but that's a good question, because it should be evidence-based. You can make reasonable inferences. You may be able to interpolate things, but I don't have a clear legal opinion on that. I know it's an issue. I know there are times when decisions on numbers can be made through inference or other data or other analysis that isn't the direct reference to actual recorded numbers, but I don't know exactly when and how that's okay.
Mhm.
And that's a really important thing to figure out here, is like, if you're going to base it on this, is that going to hold up? And I don't know the answer to that right now. So, but there's a lot of stuff that's spoken here, and some of the thoughts that I've had reading it. You know, it's a complicated question, or a series of complicated questions, and they all need to be settled to a level of high comfort to go ahead and do this. And I can't tell you right now if that's all going to happen.
Sure.
I wouldn't be opposed to having it introduced, but I think, given the letter that we did receive from their attorney and Ken's points and Ken's history. I think it should sit in committee a little bit longer and we should hammer through some of those concerns, and weigh the options. But I think if we get to a place of comfortability where it makes sense, that introducing it.
So you would keep it here rather than introduce, like, we could introduce it to the council and continue to work on it in committee? Is that an option for you, or do you prefer to keep?
I think it should stay in committee a bit longer because I think my understanding of the intention of committees is for us to do some of the,
We do.
like, we do the legwork before we introduce it to the full council.
Okay, that's fair. So I think that's a reasonable perspective. There is more work to be done. And, you know, I deliberately only put two things on the agenda tonight because I wanted to give this sufficient time. Any public
I have
comment?
one more.
Sorry,
I have one more thing after hearing all,
Yeah.
is that if the legal part of this, I don't feel, I haven't been informed enough to feel confident about, but it feels like we're gonna spend money. And so I want to just bring to our committee to think about money, because I think eventually we're gonna end up in a lawsuit. And if Ken advises us, maybe you can advise us on what lawsuits might cost.
we will not discuss any potential litigation in open meetings. We can go into executive,
Potentially.
we can go into executive session and discuss that at a future time, but that's
Okay.
not.
I'm concerned about legal
No, I
to
completely
get this
understand.
accomplished.
I completely understand that, which is why we have to go through and make sure that we're at a certain level of confidence of what we're doing.
So the previous council to common council advised against last year's.
I think we should leave any guidance that was given in executive session out of this discussion.
Okay, I would like to, as the new member, be privy to that.
We can do it in the executive session. Do we have public comment?
Yeah, I wanted to respond to Jason's question or comment earlier about 142 loads a day, 284 trips a day, which was approved by the planning board for the Hall Road. And the Columbus current dock owner can operate up to 250 days a year. That 284 trip a day limit was first came up in Craig Manning 2016 traffic evaluation study as a maximum daily cap, worst case scenario, estimated to occur twice a year. Not something that would be regularly ongoing average truck volume. And in fact, my review of the 2020 Craig Manning truck study that measured Columbus's activity from 2014 to 2019. From 2015 to 2019, they only hit that 142 or 284 2 days out of a 5-year period. Okay, so just for the planning board to approve 284 trips a day, up to 250 operating days a year. The concern is that worst case scenario, whether it be Columbus or a new dock owner down the road, could potentially run that level for 71,000 trips a year, which is a lot more than 10,000 or so.
Okay, thanks. I think we need to stay focused on the activity at the dock, which is what this is about. So, yes,
I mean, it's kind of.
yes, it has to get there somehow. But this is a focus on the dock. And so I don't really want to get into discussions of,
Just one other point that the limit in the proposed local law clarification does not preclude the planning board from putting other limits into a conditional use permit. For example, they can have the annual limit and they can also have a daily cap. No event will the daily cap exceed 284 trips a day. That's perfectly fine. So it doesn't preclude that.
Lloyd,
Yeah, Lloyd Kenny, and if for clarity's sake, could you just summarize maybe in a bullet point the 4 issues? Because I didn't quite,
I think you were going to give us a memorandum, correct?
I mean, I have this sheet that I mentioned 4 points that were like the foundation for where we are.
bullet point them for me.
Yeah, I did. I said that the dock was designated You can have one of these. I mean, it was just a note.
Okay.
Why don't you send something?
It's like a summary, though, I think what he's asking.
That's all I'm asking, because so I can think with it.
What I said is these are the four main points. Again, they're the foundation for the zoning authority on this. Now, there are lots of other issues, so these don't address all those other issues. But the dock was designated a non-conforming use in 2011 by the local law. Non-conforming uses are regulated by 32529 in the code. It says no external evidence of the use shall exceed what existed at that time. Colors purchased the dock in 2014, 3 years after all those were in place. And the Hudson Code 32017.1, whatever, the conditional use says that a conditional use may be approved for continuation of existing commercial dock operations and is more as such uses existed on the effective date of this law in 2011. So I'm just saying that the foundation for all this is that these restrictions were put in place in relation to non-conforming uses, and that the conditional use also refers back to the same 2011, so that all of the limitations that are at issue here have been in the code for 15 years. And that's why this isn't, it's not like this is coming in and imposing new ones. It's saying it is going back to the ones that have been in there for 15 years and trying to answer the question. If the court sends it back to the planning board, says, answer that question, it's got to be as it was in 2015. How are they going to answer that? And then again, if it gets sent back to them, they have to answer it, they're going to do it on their own, or you're going to give them a framework. And that's why I think, just to keep in mind, any further amendments or revisions or thoughts, keep in mind that they're there to answer the question that will come to the planning board if the court sends it back. If the court says, the code says has to be as of 2011, what is that going to mean? So that's really what this would be attempting to answer, not other things. There are lots of other things that you may think would be great to do, but if they don't answer that question, they're not going to really be relevant. So that's what this is all about. May not happen, we don't even know, but I mean, that's what this is about. If it gets sent back, how's it going to get answered?
Thank you for that clarification.
Yeah.
And any other public comment? So I want to move on to the rest of the meeting. We have a number of things that we're going to be working on. One of which Jenny brought up as a new issue relating to parking, and she has provided us with the preliminary documents. We'll take that up next month. The other issue that is on our docket, which we will address next month, I'm working currently on other municipalities and researching what kind of codes are in place relating to e-bike and scooter safety. So next month we'll be prepared to talk about those two things, and then we will continue with our review of this particular issue. If there's no other business, can we have a motion to adjourn?
Have a motion to adjourn.
Second is Jenny. Thank you all very, very much.